Uriah Woods against the state.
Yes, Mr. Fitzgerald.
My Lords, I appear with my learned friend Graham Hall for the appellant in this matter, and my learned friend Mr. Rowan Pennington-Bennett and my learned friend Daniel Goldblatt appear for the respondent state. My Lords, as the court will know, there are two issues, essentially one relating to whether the court should admit the new evidence of diminished responsibility and probably follow the course of remitting if you were to admit the evidence. And then secondly, whether there was a misdirection in relation to provocation and whether the new evidence should be admitted in relation to the subjective element of provocation. My Lords, those are set out. Can I deal with the new evidence when I come to it, because it's not a major issue, but when I come to Dr. Latham's evidence. My Lord, we say that, therefore, that this was a case where there was a fundamental misdirection at the trial on the issue of provocation, which of itself would justify quashing the conviction. And we've set that out at paragraph 61 of the case at pages 537 to 8. And my learned friend, Mr. Hall, with the board's leave, will be dealing with that issue of ground 2. But in relation to ground 1, the question is the new evidence raising the separate but important issue of diminished responsibility. That arises in the special circumstances of this case, where there has never a psychiatric assessment before the trial or before the appeal. And that's a matter of some importance, that there is no system for mandatory assessments, which has been commented on, for example, in Pitman number 2 by Lord Hughes. We say that the omission inevitably raises concerns where we're dealing with a defendant who is indigent, who has limited intellectual capacity, and was never really given an option or opportunity to put forward a defence of diminished responsibility at trial. The board will have seen the concerns expressed by his appellate lawyer, Daniel Kahn, and Mr. Kahn's fair acceptance that there should have been a psychiatric assessment commissioned even at the appellate stage. That's at page 475, paragraph 15 of his statement. I'll deal with that if I can in more detail later. But now new expert evidence has been commissioned from the two psychiatrists, Dr. Latham and Dr. Attard, and from the clinical psychologist, Ms. Leewar Cooper. That evidence we submit shows that this was, on the balance of probabilities, a case of diminished responsibilities, or can I put it in the words of Lord Bingham and Campbell, might well have been a case. That is both because of the appellant's intellectual disability found by the clinical psychologist, and that's a marked disorder. He has an IQ of 53. That is 1 in 1,000 people have that low an IQ. And then the delusional disorder diagnosed by the two psychiatric experts in detailed and carefully reasoned reports, particularly if we look at the joint statement at pages 461 to 464. We acknowledge that the evidence is not undisputed and has been the subject of criticisms, of trenchant criticisms, but it's certainly not contradicted by any independent expert evidence put forward by the respondent. And the forensic points made by the respondent are far from incontrovertible. My Lords, I'm replicating there the language used by Lord Hoffman in Cardinal Williams, saying the evidence should be admitted. It's not incontrovertible and may well be controverted when heard, but it's capable of belief. So
Gerald, can I just ask, do you say that intellectual disability or cognitive disability is a freestanding matter, or is it potent only if linked to delusional disorder?
Well, my Lord, we say that given what are described by the experts as the effects of it, that's to say limit self-control and ability to appreciate, it could be freestanding, but it's right. I have to accept that they both link it, that they combine it with the delusional disorder. But my Lord, yes, I mean, in Pitman, for example, the board remitted the matter back solely on the basis of the intellectual disability with an IQ of 53. 2, I think it was there, so almost the same.
Thank you.
My Lord, I'll go to it, but the evidence is that if you have that low level of intelligence and executive functioning, and low level of executive functioning found by Lee Weil Cooper, it has effects both on your ability to think things through, and also on your ability to control yourself. So it's both. So we invite the board to conclude that there's cogent evidence of diminished responsibility that is meeting the test in Lundy. 1, capable of belief. 2, that there's a reasonable explanation for the failure to adduce it at trial. And 3, that in any event, it's in the interests of justice to admit the new evidence, in this case where the death penalty has been imposed. I mean, the death penalty is still there. The board will obviously be aware of the unlikelihood it will be carried out, but it is still there. He has been sentenced to death. And we'll be inviting the board to take the course taken in the Trinidad case of Pittman, which is at tab 20, where the board, just anecdotally, the board remitted back to the Court of Appeal a case where there was an IQ of 53. And in the Eastern Caribbean case of Cardinal Williams and the Queen, where Lord Hoffman gave the judgment, and it was remitted back on the basis of new evidence. And they took into account the fact, firstly, that he was indigent, and secondly, that he was facing a capital charge in deciding whether there was a reasonable excuse.
Is a death sentence equivalent to a whole life sentence? Does it mean you're incarcerated for the whole of your life?
My Lord, if you're sentenced to death and it's commuted, the normal course would be to commute it to life, but there is now a mechanism whereby you can seek a long fixed term instead.
Right, but at the moment, if the appeal fails here, what is the state, or what is his situation?
He remains sentenced to death.
Yes.
And that death.
So what does that mean in reality? So it's not carried out.
Well,
it means you're on death row permanently, does it?
My Lord, yes. Until you file a constitutional motion saying that I've been on death row for 5 years and therefore I can't be executed. At that point, the court can grant relief, including commuting the sentence. And
I see.
Yes.
I see.
My Lord, I mean, that's a matter that the board has given judgment on in the case.
Yes, no, I didn't know what. I just wanted to know.
No, my Lord. But in words of Lord Bingham, he has had those words. You will be hanged by the death till you're dead pronounced, and that remains the sentence at the moment.
Although you say because it's more than 5 years ago, he's now would be entitled to have it commuted?
Yes, my Lord. As a matter of constitution, yes, he would accept that.
Okay.
My Lord. And, my Lord, the other case is the Winston Solomon case, which I'll take you to. That was another case where evidence was adduced on appeal to the Privy Council. He had denied any involvement at the time of the original trial. New evidence was adduced for the first time on appeal, and the course taken by your Lordship's board was to remit the case, remit the case back for consideration, both as to whether to admit the evidence and as whether to allow the appeal. In fact, we've put that in the supplementary bundle, the Winston Solomon case. It's tab 2 of the supplementary bundle. My Lords, can I just then go to the background history? And because the statement of facts and issues is fairly short, can I just supplement it somewhat? Because obviously the board will be interested in knowing whether there was evidence suggesting, one, a loss of self-control, and two, mental disorder. So just, you have it in the SFI at paragraphs 7 to 10 at page 498. Although it says he had 2 children, he had in fact 3. Can I just whiz through it? On the 10th of February, there was a complaint by Sandra Miller and the appellant's 2 elder sons by her, Ryan, aged 12, and Jerevan, aged 11, of an assault on them by the appellant. It's referred to in the bundle at page 9, and Uriah Woods' evidence on the assault on him and on the children and the mother is at pages 205 to 206 of the electronic bundle. At some stage later in the month, Miss Miller and the children left Parrot Hall, where they'd been living with the appellant together as a family. They moved to Leeward Cross. According to Alan Porter, he offered Miss Miller accommodation on the 10th of February, and she took him up on it some 3 weeks later. That's his evidence at page EB 177. So he would have been there, they would have moved at the end of February. The judge summed up on the basis that Miss Miller left shortly after the assault. That's at page 242, lines 20 to 25. But this is important. The Free Boys still visited the appellant after that. That was their own evidence. Uriah Woods' evidence at page 208 of the electronic bundle, and Darian Woods' evidence at page 214. So there was an ongoing relationship with the children. On the 14th of February, there was the poison incident, where the appellant appears to have ingested what he described as a milkshake containing poison. My lords, at EB 11, you have the report that he made to the police and about taking the. So the poisoning for the appellant's report to the police is at EB 11, and drinking the milkshake and losing consciousness. And you can see the hospital notes about it at page 87 of the bundle, where you can see there in typically legible medical notes, 42-year-old man brought in to A&E unresponsive, found by wife at home frothing and unresponsive. That is important. It was his wife who found him and called the ambulance. So that's an irrelevant factor, because the prosecution say it's clear that she did try to poison him, but Dr. Attard rightly points out that she actually was the person who called the ambulance, and that's recorded contemporaneously by the hospital notes. Alan Porter stated that after the poisoning, the appellant was taken to hospital and treated for suspected poisoning. He began accusing Sandra of poisoning him. That's at in the EB paragraph 97 of Dr. Attard, but it's in his evidence too. Though the appellant...
Just really, does the medical note refer to the urine result?
Yes.
Disclosing various substances?
Yes, my lord, you're absolutely right. Toluene and phenyl, agricultural poison, yeah. My lord, the simple point we respectfully make is that that the only thing we know is that he took poison. Whether she did it, which the prosecution alleges the inference should be drawn, Dr. Attard gives two very good reasons why not. And one of them is that she was the person who found him and got him taken to hospital. The other is that the police took no action against her. It's true that the appellant did blame Ms. Miller for this, but in fact, we make the point significant. She was the person who found him and got him to hospital, and the police took no action. Both of those points are made by Dr. Attard at paragraph 100 of his report, page 452. So we say that on balance, we'd invite the conclusion that it was probably an unfounded allegation that he was making. On the 21st of February 2005, the appellant subsequently made a complaint to the police.
Does that matter? I mean, does it make it delusional? Might it not be sufficient that he had a reasonable suspicion, even if it, in fact, whether or not it in fact was true or not, it's not really the point, is it?
My lord, I think that's where the first stage is it was probably untrue. The second stage is to look at the clinical assessment of how he maintains it and how he maintains it. I think his wife said to him, well, actually, I took some of the stuff that you're complaining myself. And he said, and he rejected that. So it's a question of the timbre in which you express the thing, the way in which you maintain it, the fixated nature in which you maintain it, irrespective of any evidence to the contrary. That's what the psychiatrists say, that it's not, and then of course there's the elaboration that he also suspected her of serial infidelity, not just going off with someone who she became engaged to, but of serial infidelity before that, based on typical symptoms of saying, I could smell other men on her over a period of time. So it's that and the other delusions, my lord. But my lord, I accepted, if one looks at the case of Ahmed Din, which I wouldn't commend in other ways, but as an example of justice. But my lord, your lordship's quite right that the way it's framed there is whether there's no probable basis for the suspicion. But on the 21st of February, the appellant subsequently made a complaint to the police, and he returned to the police station, so that's at EB 451, para 97 of Dr. Attard. He returned to the police station on the 9th of March. We've got at EB 12 the police report, and he was due to make a statement on the 12th of March, but didn't attend. That's at EB 13. From what the appellant later told Dr. Attard, it appears that he held the belief that both Miss Miller and her new partner were trying to kill him. That's Dr. Attard at paragraphs 95 to 6. And that her new partner was following him. That's Dr. Attard at paragraph 95, EB 451. Miss Miller left the appellant at the end of February 2005. That's assuming that the 3 weeks after the incident is the correct assessment, so at the end of February, and moved to Leeward Croft. Subsequently, she took up with a new partner, Lawrence Stewart, and on Miss Stewart's evidence, he and Miss Miller met in May of 2005, and then they became engaged on the 3rd of July, CEB, page 179.
Forgive me, Mr. Fitzgerald, the date on which she left?
Well, my lord, all we have is that the Alan Porter says that he offered her accommodation on the 10th of February, and she took him up on it some 3 weeks later. And that's, my lord, his evidence at page 177. My lord, it seems that he would have been still in the house they would have both been still in the house on the 14th of February when the poison incident takes place.
Thank you.
But if not, if the judge in summing up said she upped and left straight after, but Alan Porter says, actually, I offered her a place straight after, she left 21 days after. No, that's the background. And then...
Sorry, you said they were both in the house on the 21st or the 14th when the poisoning took place?
Yes. Well, 14th. Yes.
The hospital notes are the 21st.
Yes. Oh, my lord, I think they're wrong on that because he makes the complaint to the police on the 21st of February after he recovers in hospital. So I think they're referring to the fact that that's when the incident took place.
Thank you.
My lord, I have written all this out, but since we're not allowed to give speaking notes, I can't hand it in. But it is you've got every reference you need if necessary. My lord, the fatal incident. Then it appears then on the 14th of July 2005, the appellant threatened Lawrence Stewart and pelted him with Guinness bottles. That's Lawrence Stewart's evidence at page 179. And it's referred to in the summing up at page 267, lines 24 to 29. And the appellant told him to leave my girlfriend alone, and that's EB 182. Mr. Stewart reported this to the police on the 14th of July at 1:50 p.m., so early afternoon, and that's EB page 14, his report to the police. The fatal incident, then coming to that, at the night on the 14th of July, the appellant came to Leeward Croft, where Miss Miller was living with her children. At 10:30 p.m. that night, her new partner, Mr. Stewart, was with her in bed. Darian, that's a 6-year-old's youngest son, was in the bed too. That's in the Lawrence Stewart's evidence at EB page 180, and it's in the summing up at page 268. My Lord, just to give you the eyewitnesses who were present during the fatal incident were Lawrence Stewart. His evidence starts at page 178 of the EB. Jose Murray and Ricky Guy, the appellant's stepsons. That's EB 167 and 191. Ryan Woods, the appellant's eldest son by Miss Miller, and Darian Woods, the appellant's youngest son, the 6-year-old by Miss Miller, and then Jerevan Woods, the appellant's second son, who didn't give evidence. According to Mr. Stewart, the appellant came in armed with a cutlass and started to chop Sandra like a madman. That's at page 181 of the bundle. And he repeats that several times, Mr. Stewart, that the appellant started to chop like a madman. There were numerous blows, I think 22 in all, and the appellant further severed the foot of his 6-year-old son, youngest son, Darian, with whom he had no apparent animus. The reference to that happening is in Darian's own evidence at EB 212, because by the time of the trial he was 16 and giving evidence. His eldest son, Ryan, described the appellant as, I quote, in a rage that night. And that's EB, page 210. According to the appellant in his evidence, he said this: I see the guy on the bed in a boxers, and I see Sandra with a panty and a vest on, and I tip just so. My head was there at that time, and he didn't remember the events after that. That's at EB, page 218. Later, this is at page 221, the appellant stated in cross-examination that when he said, I trip, I mean, I don't know myself when I chop Sandra. That's at page 221. I don't know myself. And in cross-examination at page 223, he said, by saying I don't know myself, I mean I don't know which part I was and what's going on in my life. So that's at page 223. The appellant's account of Miss Miller and Mr. Stewart being in a state of undress was confirmed by Ricky Guy in cross-examination. That's in the summing up at page 268, lines 23 to 33. And Corporal Best observed Miss Miller clad in a vest and underwear when he had attended the scene. That's in the summing up at page 268, lines 35 to 38. The judge says effectively the evidence is that she was in that state, although some of the evidence denied that. Some of the witnesses denied. Mr. Stewart did admit that they were both lying down in the bed together. And, my lord, there is evidence that that after that he ran away and there was a fire started in his house. That's in the EB at pages 19 to 20, and again at page 124 in the evidence of Corporal Best. Whether it was started by him himself in a fit of despair or by someone else, history doesn't relate. My lord, just this final matter on the facts. In his account to Dr. Attard, the appellant referred to his belief in his wife's persistent infidelity from about 2001. See Dr. Attard at paragraphs 41 to 3. He referred to, that's page 440. He referred at page 441 to her attempt to kill him at least 3 times. That's at page 441, paragraph 46. And to being followed by Mr. Stewart. That's Dr. Attard at paragraph 95, page 451. In his earlier account to Dr. Latham, the appellant explained his belief that Miss Miller was being unfaithful was based on the smell when having oral sex with her. That's at paragraph 15 on page 403. And again at paragraph 49 at page 411. That's the Dr. Latham. And Dr. Latham says this is a classic, as it were, delusional presentation. His repeated assertion that their relationship, sorry, my lord, there's a further point I just make myself. The evidence of all the other witnesses was that the relationship had ended in February when she left and moved to Leeward Croft, whether straight after or at the end of February. But his account was that the relationship continued. She was still my girlfriend, and they were visiting to and fro. And there's no doubt that he was seeing his children. The children gave evidence that they were continuing to visit him at his old house. But he was saying we were still in a relationship. Now,
there's an inherent difficulty, though, isn't there, in the evidence or accounts that he's giving now 15 or 20 years after something happened.
yeah, yes.
He's had years to dwell on this and for his mind to think up new ideas, or it seems impossible, really, to disentangle what is construct afterwards from, because we just don't have any contemporaneous accounts of what his state of mind was, do we, apart from his evidence in court?
Yeah, his evidence in court and the observations of other people of how he was behaving, yes. My Lord, I mean, the obvious one is chopping like a madman. But, my Lord, this is not... It's not a situation which the courts have never met before, of having someone reconstructing later. I accept, my Lord, that there are all the infirmities of that evidence, but there is an account given. He clearly was saying, she's poisoning me, obsessively at the time. He's reporting to the police 3 times. He's...
Well, he'd been in hospital.
Well,
After drinking something he found in the fridge that he shared with her. It's not altogether surprising.
no, well, my Lord, we don't know whether... Well, again, if we're saying he's an unreliable memorial, the only fact we know is he ended up in hospital having taken poison. Whether the question of whether it was administered by her or what she did leave it...
But there's nothing to suggest that he's coming to the house in July had anything to do with the poisoning, is there?
Well, my Lord, except that if you're building up a resentment and spreading it, that may well influence you when you engage in an attack of homicidal violence. I mean, my Lord, this was an extreme... All I can say is there was an attack of extreme violence, accompanied by "I'm going to kill you," and that when he the evidence is that he...
Well, unfortunately, it's not unknown for obsessive and jealous people, when their partner leaves them for somewhere else, to go and kill them without any poisoning coming into the mix.
My Lord, I accept that. The question is whether, in this case, there is the added element of mental disorder, and that we rely on the fact that he was alleging he had been poisoned. We say unreasonably. And his description of his delusions. I mean, this is a man of my Lord, it's a very low intelligence.
Well, I know.
If it's being said that he's inventing it all.
No.
He just happens to hit on classic symptoms of serial infidelity. I could smell them on her, which are characteristic of delusional jealousy. My Lord, I accept, my Lord, that it's difficult to reconstruct. I just simply say that this would be a matter where, given that 2 psychiatrists have carefully analysed it and come to the conclusion that it is delusional, deserves to be remitted, to be tested. My Lord, obviously all the points that Your Lordship and my learned friends make would have to be considered.
Mr. Fitzgerald, a particular difficulty I'm having is that I was of the impression that for belief to qualify as delusional, it had to be false. And the context here is that there's actually poisoning.
Yes.
Now, in the further report of Dr. Latham, I think it is, we are being told it's rather more fluid than that. It doesn't have to be false.
Well, yes, my Lord, there are 2 aspects of it. My Lord's absolutely right. Firstly, if it's necessary to conclude that it is false, and that is the primary definition of a delusion, then we say on the balance of probabilities it was false. But secondly, what Dr. Latham says is, you can have an event, the guy did ingest poison, there's no doubt about it, whether he did it accidentally or because someone deliberately put it there, we don't. But he did ingest poison, he did nearly die. That's the event. We know that he ingested poison. Did he delusionally attribute it to his wife because he thought she was also being unfaithful and all this? Had she actually done it? We say, on balance, she hadn't done it. But my lord, then as your lordship says, it's slightly more fluid, because what Dr. Latham is saying is, you have to, if you look at the overall contents of his delusional beliefs, the belief in persistent infidelity is the one that he looks at, and the poisoning allegation, and the way they're maintained, irrespective of evidence to the contrary. And I'm trying to give the clinical, but it's really the flavour or the timbre in which it's expressed. This looks to him and looks to Dr. Attard like a delusional belief. And my lord, I accept that that is a difficult thing to convey without hearing oral evidence from the psychiatrist about how you form that view. But it is a view that they form on the basis of their clinical experience.
So a delusional derangement essentially based upon a delusional obsession.
Yeah, my lord, yes. I mean, it's a classic thing to say, I can smell other men on you. Classic delusional, and it's a distortion of reality brought about by the mind playing tricks on the person. And he expresses those to Dr. Latham. My lord's right that it's only to Dr. Latham that he expresses them, and to Dr. Attard some years later. But given his low intelligence, we say he's not malingering or inventing. He genuinely believes this. My lord, that's how we respectfully put it. So, can I just, so then, just to carry on with the chronology, it's true that in his interview with his lawyer in November 2010, and that's Mr. Welsh, the appellant denied the offence and blamed Mr. Lawrence. You have that at, you have the first interview at EB 100 and the second interview at pages 101 to 106. But he clearly referred to his belief that he was being poisoned, so he's maintaining that belief. Admittedly, that's 6 years on from the events. And he refers to, in 2010, at page 100, she poisoned Woods, and in March 2011, page 101, I was poisoned by Sandra Miller, that's page 101. And then he also...
Sorry, what are these notes at 101?
Those are the notes of what he said to his lawyer.
I see.
Yes, my lord. So you've got, at page 100, you've got the first interview in November 2010, and at page 101 to 106, you've got the second interview with his lawyer, and he's referring to being poisoned by Sandra Miller, that's page 101, and then he says that as to Mr. Lawrence, he says he used to cuss me in 2005. He used to cuss at me in 2005, and he's sort of saying, I think he disliked me, as it were, before. Then he blames Lawrence for the killing. So he's putting forward, I didn't do it, Lawrence did. We say a somewhat puerile account, consistent with his low intelligence at the time. But then we make the point that before his trial he was not assessed psychiatrically, as there's no system of psychiatric assessment for those facing capital charges. Can I just give you the reference? It's in Lord Hughes's judgment in Pittman and the State, at tab 21 of the Authorities Bundle, page 977, paragraph 48, and where he says, until there's a system of mandatory assessment, we're going to get these problems. And Daniel Kahn refers to that, the absence of mandatory assessment, at pages 477 to 478. And so...
He's asked if we could have a short
Yes, yes, certainly. Yes. We're going to have to adjourn for a short time.
I'm so sorry.
We'll resume as soon as possible. Yes, Mr. Fitzgerald.
I dealt with the interview with his lawyer in November 2010 and then his further interview in March 2011, which you have at pages 101 to 106. And it's right, he denied the offence there, but he clearly referred to his belief he was being poisoned. By the time of the trial, the appellant was not denying the offence. I mean, he was saying, I tripped, but he wasn't saying someone else did it. We make the point that before his trial, the appellant was not assessed psychiatrically because of the absence of a system for that. And I've given you the references to that in the judgment of Lord Hughes in Pitman number 2 and in Daniel Kahn's statement at page 477 to 478. But provocation was put to the jury and in giving his evidence on oath, he didn't deny responsibility for the killing. My Lord, just briefly, his trial counsel has failed to answer 2 letters written on the 14th of February 2019, see chronology at page 511, and the 10th of January 2020, see page 511, and those letters did waive privilege and invite his comments. 2 points, sorry, I'm 2.6 mine. Turning to the original appeal, it's right that leave was not sought to reduce evidence of diminished responsibility, and the issue was not raised on appeal. You have the Court of Appeal judgment at page 355. However, the board will have seen that on the 9th of June 2017, the appellant sent a letter to his then representative, Daniel Kahn, instructing him, this is at page 481, please file as part of my legal arguments the fact of diminished responsibility or temporal insanity. Now, of course, the prosecution say, well, this is evidence of him being astute and tactical. It may just be evidence of someone being told that this is what you do when you're facing the death penalty by other prisoners. We don't know, but we say that this is indicative, perhaps, of the desperation of someone facing the death penalty, because, of course, he would, at that stage, in 2017, still have been facing the reality of a threat of execution. But it hardly suggests, we say, sophisticated intellectual function or astute legal strategy. Mr. Kahn explains that he did not secure a psychiatric assessment. He states, and this is at page 473 to 4, paras 5 to 7, that he believed the appellant to be of low intelligence, and he noted that, but he viewed the prospects of success of diminished responsibility as not reasonable in the light of the case law of the Trinidadian Court of Appeal, and he referred to the case of Pitman when it was referred back. Moreover, he also referred to limited resources of legal aid funds and delays in the justice system. That's at paragraph 16, page 474. He did confirm, and this is at paragraph 10 of Mr. Kahn at page 474 to 5, that the appellant had a fixation that he was being poisoned by the deceased. And Mr. Kahn made the point that the low intelligence and fixation of the appellant did cause me deep concern. This is at paragraph 15 of his report. The low intelligence and fixation of the appellant did cause me deep concern, and I humbly accept that it would have been best practice to have the appellant evaluated. So we say Mr. Kahn's own recognition of the appellant's low intelligence just from dealing with him is significant. It chimes with Miss Leroy Cooper's psychological assessment. She found the appellant had a full-scale IQ of 53, that's page 419, in the lowest 0.1% percentile for individuals of his age. She also identified him as extremely low conceptual functioning, a score of 62, that's in EB page 423, and diagnosed an intellectual development disorder at page 425, with consequences, she said, for thinking rationally and making judgments. And he also had below average scores for executive functioning, which she said suggested he might struggle with self-control and exhibit greater impulsivity. That's at the bottom of page 425. The whole history of how the appellant's mental state was examined is set out in the chronology at pages 511 to 513. But my lords, just so that's it. Can I then just address the question of the legal test for raising diminished responsibility on appeal? We've dealt with that in the case at Part D, citing the authority of Lundy, with the test of is the evidence credible and capable of belief? Secondly, is there a reasonable excuse? And thirdly, even if there isn't a reasonable excuse for adducing it sooner, is there a risk of a miscarriage of justice? The overwhelming thing. And that's been replicated in the, by the Court of Appeal in Trinidad interpreting section 47. 47 just says may admit the evidence. And they've said that the test is, first of all, you ask yourself, is it capable of belief? Secondly, is there a reasonable explanation? But thirdly, there's an overriding, even if there isn't a reasonable explanation, an overriding power to admit it in the interests of justice. And that's in the case of Winston Solomon, the Chief Justice of Trinidad interpreting section 47. My lords, we invite the board to admit the new evidence of diminished responsibility from the three medical experts, which is not contradicted by any evidence from the prosecution, and they together conclude that he was likely suffering from mental disorder, both delusional disorder and intellectual disability. And secondly, we invite the board to allow the appeal and to remit the matter to the Court of Appeal to determine whether, in the light of the new evidence, a verdict of diminished responsibility should be substituted. My lords, just two cases which may be of assistance. One is Pittman and the State, tab 20, and page 939 of the e-bundle. And my lords, if I can just, it's the discussion. This is a case where the person was about to be executed and he came before the Privy Council with new evidence that he was had an IQ of 52. And the judgment of Lord Carswell summarises the new evidence from page 950, paragraph 26 onwards. The two medical reports are referred to, and you'll see the IQ test was 52 in that case, at paragraph 27. So very similar to this case in terms of the IQ. And then there was some other evidence of him being of very low intelligence in the estimation of his lawyers, like in this case. And there are a number of issues it could go to, but if I can just focus on the test, para 31, page 951, section 47 of the Supreme Court of Judicature of Trinidad gives the court power in a criminal appeal to receive fresh evidence if it thinks it necessary or expedient in the interests of justice. It was made clear by Chief Justice de la Bastide that the breadth and generality of this power do not remove the long-accepted requirements of the law, that fresh evidence should appear to be capable of belief and that a reasonable explanation be furnished. These factors are not, however, conclusive on the admission of fresh evidence, and an appellate court has the overriding statutory power to admit it if it is in the interests of justice, and then they cite Benedetto and Smalling, two other Privy Council cases. Their lordships have given careful consideration to the evidence now put before it, and have come to the conclusion that it should be admitted for several reasons. First, they are of the opinion the evidence appears capable of belief. That was the IQ of 53. The medical opinions are given by reputable practitioners, and although the appellant's advisors furnish the solicitors acting on the state with copies of their reports and offer them an opportunity to have their own medical examination, they did not take advantage of the offer. So very similar to our present situation. Secondly, although it is possible that the doctors would qualify their opinions if their evidence were tested, or contrary opinions may yet be given, prima facie the extent of the appellant's intellectual handicap is substantial and such as to require proper investigation by the court, we say analogous to this case. And thirdly, the explanation proffered for failure to adduce medical evidence at trial may be regarded as reasonable. And then it cites Cardinal Williams. Cardinal Williams, which is at tab 24, gives a very simple explanation of why it's admissible, which is that he's indigent and facing a death penalty. And your Lordships will see at page 1012. This is
the electronic bundle reference?
Yeah, 1012, yes, madam. 1012. In fact, Lord Hoffman there addresses the power, which I know my Lord will be familiar with, of mandatory admission. If they have to admit it, if you've got a reasonable explanation it's capable of belief, they can, in any event, under another section, admit it in the interests of justice. That's in all the Eastern Caribbean states. Their Lordships consider that Dr. Eastman's, this is at page 1012 at B, Eastman's evidence is likely to be credible in the sense that it satisfies the test of being apparently credible, though it need not be incontrovertible. It may be that after cross-examination or consideration of evidence in rebuttal, his would be controverted and rejected. This is a matter going to wait. Lordships consider that it passes the threshold test for admissibility, so credible but not incontrovertible. As for section 45, they consider that if one has regard to the realities of the position of a relatively indigent defendant on a capital charge in St. Vincent, a reasonable explanation for the appellant's failure to adduce such evidence earlier readily suggests itself. So you don't have mandatory testing, you have limited funds, and the matter is not looked into. Their Lordships would therefore on this ground remit the appeal to the Court of Appeal to decide how best to deal with Eastman's evidence. The court makers. And so that case was remitted to the Eastern Caribbean Court of Appeal, and it was dealt with by Chief Justice Byron and Justice of Appeal Saunders, and they did allow the appeal and substitute manslaughter in the Cardinal Williams case. Can I then go back to page 952, para 32? Since the fresh evidence is capable of belief, of having effect to which they've referred, the Lordships consider the conviction is potentially unsafe and requires review, they accordingly propose to remit the case to the Court of Appeal, who should determine the safety of the conviction in the light of the fresh evidence, together with any rebutting evidence which they may decide to admit, applying the principles laid down in Pendleton. And then one of the issues it will go to is diminished responsibility. I think that's all I need to take the court to, those two cases. But there is just one more, which is in the supplementary bundle, which is the case of Winston Solomon. And, my lords, because that again is a Trinidad case interpreting section 47. And if I can take the board very briefly to the supplementary bundle at page 5, you'll see Lord Staines's judgment there in Solomon and the state.
Sorry, supplemental bundle at page?
Page 5, my lord.
Yes.
Does the board have? So you'll see, actually you can get it all from the head note, I think. In view of the fact that new material before the board suggested that at the time of the killing, the appellant had suffered from a major depressive illness, although the material was incomplete in a clinical sense, or at least that he might have suffered from such illness, the proper course was for the board to make an order in terms agreed between the appellants and respondents' counsel, setting aside the existing decision in order to enable such a court to examine any issues arising. So that's what was done, and then the reasoning on this issue is from page 9D onwards, the new evidence about the appellant's state. And they make the order. Can I, if the board wishes to see what happened when it was remitted, the Solomon case is at page 56, and it was Chief Justice de la Bastide who gives the interpretation of section 47 there, and you can find that at pages 90 onwards, from the bottom of 90 onwards, referring to the broad, that even if, as in Solomon, you say, I wasn't there, I didn't do it, if you adduce new evidence of diminished responsibility, even at the late stage of the Privy Council, they can admit it in the interests of justice. and they admitted the evidence, partly on the basis that the state should have disclosed his past history, and partly on the basis that the evidence was from two responsible psychiatrists. My lord, that's the Solomon case. So, my lords, there have been, in Cardinal Williams and Solomon, cases where the matter's been remitted. The Court of Appeal in either Trinidad or the Eastern Caribbean have considered it and allowed the appeal on the basis that the correct verdict was diminished, even where at trial, as in Cardinal Williams or Pittman, the person was simply saying, I wasn't there and I didn't do it at all. So, my lord, that's why I give those three examples of death penalty cases, because they are, one, they interpret Section 47, which is what we're on, and two, they indicate how the principles apply. My lord, I think that's Pittman, Cardinal Williams, and Winston Solomon. So if I can just very briefly address you then on reasonable explanation. We say that in this case there is a reasonable explanation. We deal with it in the case shortly at paragraph 29, EB 527. But can I just put we say there are three reasonable explanations here. Firstly, the appellant is an indigent prisoner, which is recognised as a significant factor in Cardinal Williams. I've just shown you that at 1012 C to D. Secondly, he suffers from a significant intellectual impairment, as confirmed by the tests conducted by Ms. Leewar Cooper, and that's at pages 420 to 5. And thirdly, there is no system of mandatory psychiatric assessment of those facing capital charges in Trinidad, which creates obvious problems. So those are the three grounds. Against that background, I would say there's no evidence to suggest that the appellant made an informed and capacitous election not to advance diminished responsibility, since he was deprived of the necessary information and advice to make such an election. If you don't have a report, you can't really make a decision. And in the UK, of course, where it's mandatory.
Informed and I didn't get the second adjective.
Capacitous. I don't know whether that's an English word, but yes. Capacitated or whatever one.
Precisely, do you mean? By
but you know what? Do you know what I mean? You don't know what I mean.
I'm not quite.
Oh, sorry. Okay. Was he someone who had the capacity to make a decision given his low intelligence? I mean, I say you can't make a decision until you've got the information, because it's not an informed decision. But in any event, given his low intelligence, it's difficult to say that he made a fully capacitated decision. I will not run diminished responsibility, though I appreciate the election I have to make. So, my lord, I hope that helps.
Thank you.
Whatever the word is, did he have the capacity to make a decision? Yes. Did he have the information to make the decision? We say neither. If a person is of low intelligence, has not even been assessed, he can hardly make an informed decision as to whether to put forward diminished responsibility. Moreover, we invite the board to reject the respondent's suggestion that diminished responsibility would have been a bad defence and remains so. The appellant was not at trial disputing his responsibility. He was saying, I got there and I flipped, as it were. And I can't remember, but he wasn't saying, I didn't do it. He wasn't saying, as he originally said to his counsel, someone else did it. He was repeatedly described by the principal witness as acting in a mad way, and there is evidence of both an intellectual disability and a mental disorder. Given all this, diminished responsibility would have been a defence worthy of consideration both at trial and on appeal, particularly when facing a capital charge. Nor, we say, is it inconsistent with the alternative defence of provocation, since a person of diminished responsibility to control themselves through mental disorder can also be provoked to lose self-control in such a way as to raise a provocation defence. The only difference is, I suppose, that if the jury accepted the evidence or formed the view that he had formed an intent to kill before, then that would be consistent with diminished, but less consistent with provocation. Although I suppose you could have a situation where someone is then, and this is perhaps this case, is tipped over the edge by what they see when they get there. But diminished is, if they say, you had been planning this for weeks, you'd been ruminating on this, you'd be thinking, you say, yeah, well, that's fine, that's diminished, because your intellectual deficit is operating and your delusional state is operating.
That's why you say the delusional obsession was...
Yeah, my lord, actually, I'm very grateful. That's probably the best way of putting it. So we say there is no explanation from the appellant's trial lawyer as to why no psychiatric examination was sought at the time of trial. We do have the explanation of Daniel Kahn. You've seen that. He said it would have been better if we got it. And he expresses his deep concern that he didn't look into that. And then there's the further fact that the appellant himself may well have lacked sufficient intellectual insight and sufficient information to understand or address the issue of what was in his best interests. There's parallels with the case of Erskine and Williams, which is in the bundle at tab 37, paragraph 95. That's a case where Erskine, who by the time of the appeal it was clear was suffering from lifelong schizophrenia, at the time of the trial elected to, as it were, put the prosecution to proof, and so didn't admit it.
Page reference to Erskine.
My lord, it's page 1222, my lord, paragraph 95. Erskine, it's the leading case in our Court of Appeal on. So he originally was denying it and put the prosecution to proof, and then eventually it became clear he did do it, but that he was suffering from schizophrenia, and that's where Lord Judge, I think, he gives a judgment on the test that even where you deny it, if it's clear that you were disordered, that's what matters. And then the same in Ex parte Pearson, she was a woman who denied the killing of her love rival, as it were, but then admitted it, and they didn't judicially review the CCRC's decision not to refer the case back, but Lord Bingham said that the important thing is that the person should not be punished, as it were, for the disability from which they suffer, from the psychological failings for which they suffer. And that's cited in Erskine and Williams at paragraph 90. My lord.
90?
90, yes. I hope it is anyway. Can I just check?
Is Erskine another one of yours, Mr. Fitzgerald?
I fear it is, my lord.
What?
Yes, please.
You seem to have been counselling all the ones we've seen so far.
Well, my lord, Lundy's not mine. But my lord, yes, Erskine is. My lord, and they cite that. So finally, once the issue, well, I wasn't in Cardinal Williams, my lord. That was James Guthrie, QC. But I was there when it was heard in the Eastern Caribbean Court of Appeal, and Chief Justice Byron accepted the evidence that had been remitted back and substituted manslaughter. So, my lord, I mean, because there's a little bit of a tang of in the citation from the Chief Justice of Trinidad in Daniel Kahn's statement of why the Privy Council keeps sending us back these cases. In fact, when they sent back Cardinal Williams, the appeal was allowed. When they sent back Winston Solomon, the appeal was allowed. And it's simply, Pittman was not allowed, but they took 4 years to give the judgment, and then commuted the sentence because of the long delay. So as it were, it's not the case that when the Privy Council says we think this matter needs further examination, that on further examination it turns out that there wasn't something to be concerned about.
Mr. Fitzgerald, do you accept that at this stage there is an evaluative function for the board?
I do.
In relation to, and to what extent, how would you suggest that we go about that evaluation?
Okay. My Lord, I accept that if the board concluded that the evidence of intellectual disability was not capable of belief, you could say, well, it's just simply not capable of belief. And if you concluded that the evidence, expert evidence of delusional disorder was not capable of belief, you could, as it were, end it here. But, my Lord, recalling what the citation that Lord Hoffman gives in Cardinal Williams, I think it's from Lord Denning, capable of belief does not mean incontrovertible. I mean, the fact there's a vigorous debate on the issue doesn't mean that it's not capable of belief and shouldn't be considered. So the mere fact that they've put in at a rather late stage a 24-page demolition or attempted demolition job of the evidence does not mean that the board can't say, well, these are issues which really ought to be determined by the Court of Appeal in Trinidad. My Lord, the interests of justice, we say that if the board were to conclude the explanation is unsatisfactory, even late evidence that should have been adduced can be admitted where it is in the overall interests of justice. And, my Lord, then can I just go then to the evidence and say that it is reliable and significant? Dr. Latham's evidence, firstly, Dr. Latham's report, we say, which you have at pages 397 to 417, is balanced and moderate, and it's not the case that he expresses complete agnosticism on the issue of whether a delusional disorder was present. In other words, he doesn't just say, well, I can't say. He does express the view that it was present. He recognises that it was an important question whether the appellant's belief as to the poisoning in particular was based on a real event, and that's at para 47, at paragraph 47 at page 410. So he recognises their issue, but he goes on to reach clinical conclusions as to whether the appellant did in fact suffer from a delusional disorder. At paragraphs 49 to 50, he identifies clinical factors which led him to the conclusion the appellant did have delusional beliefs. He says a further way in which this can be defined is by reference to delusions which are bizarre. They're not clearly implausible, his beliefs. There's evidence that he is justified in holding these beliefs, but it's obviously not a psychiatric comment on the facts. If it is correct, then that his partner had multiple relationships for many years. She was indeed trying to kill him. It's not delusion, there's no doubt. There are, however, some clinical features that suggest he may be delusional, even if there was a real event that served as a trigger, i.e. if there was a poisoning. Delusionally jealous people often interpret small pieces of evidence in a way that is highly distorted. They may also seek these small pieces of evidence in a very determined way. He was adamant that he could smell other people on his wife, and he could tell she was having sex with other men from her underwear. And that was for some years before that he was saying that. He was unshakable in his beliefs about this. This kind of assertion is commonly seen in people who are delusionally jealous. Even if there was some basis for him developing beliefs, he had their fixed nature, the associated behaviour, and their continued prominence in his mental state suggest that the diagnosis of delusional disorder may apply. This was apparently present from some time, approximately before that's to do with the infidelity belief, and delusions of this nature often resistance to treatment. And then he goes on to deal, he identifies those clinical features. At paragraph 50, he says that he relies on the fixed nature and the continued prominence. And then going on, he goes on at paragraph 54 to consider their likely and probable effect on his responsibility, Paragraph 54, mental state at the time was likely to have been affected by the beliefs he held about his partner. He believed them to be both involved in trying to kill him, and further he believed that his ex-partner had been serially unfaithful. These beliefs were probably representative of an abnormality of mind, delusional disorder. The impact was on his general attitude towards his ex-partner and was likely to have contributed to his anger about the situation he perceived. There was a clear impact on his ability to make rational judgments, believed he was a victim of attempts to kill him, strong basis for believing he lost control, and these delusional beliefs were likely to have impaired his ability to control himself, and then likely to have been suffering from an abnormality of mind by way of impairing his ability to think rationally. Delusions are by definition fixed, unshakable, and held with utter conviction. The delusion leads the person. If delusions are present, then the ability to consider conflicting information, adapt your decision-making based on possible, is severely impaired. My Lords, of course, the test of impairment is significant and appreciable rather than total. That's the case of Gold. So used to be more than minimal, less than total, but after the decision of the Supreme Court in Gold, probably the best expression of it is there a significant and appreciable effect on responsibility? It doesn't have to be the total explanation, but it has to have a significant and appreciable impact.
So what was that authority?
It's the case of Gold, my Lord. It's in the supplemental authorities.
At page?
Yes, I'll give it to you, but my Lord. Gold is at tab 4 in the supplemental authorities, and it's at page 37, where they give the gloss, significant and appreciable, as probably the best one can do for substantial if you're going to do it. And then they talk about it, the test is at 43, subparagraph 2, page 38, significantly contributed to the committing of the offence. So it doesn't have to be the whole explanation, it just has to have some reduction. And that's consistent, not just with the authority, but with the whole point of diminished, which was to give a reason not to apply the death penalty in 1957, if there was a significant and appreciable effect. My Lords, we say his original views, Dr. Latham's original, were expressed in a provisional way. Oh, sorry, I should just deal with this. He also explained how the appellant's low intellectual functioning was likely to have contributed to his ability to reason and control himself. So again, as my Lord, Lord Lloyd-Jones put to me, that could of itself be a reason for the significant diminution of responsibility. His low intellectual function is also likely to contribute to undermining any opportunity to different decisions, fewer cognitive reserves by virtue of his intellectual disability. And so we say there's that factor at page 414, and then he expresses his views at paragraph 59. He says, likely to be delusional, but he rightly says, I want a psychological test checked and I'd like a second opinion. Now, my learned friends rely on the fact that he's tentative. We say that shows how responsible he was. And then when he gets Dr. Attard's fortifying or reinforcing view, he signs the joint statement, which you have at page 464 of the EB. And at page 464, you see, well, if we look at 463 to 464, bottom of 463, paragraph 5, delusional disorder is a medical diagnosis. They all agree on this. The diagnosis is not based on accepting, has never been violent. The delusional disorder type that has been diagnosed is, however, known to be associated with violence. The opinion on the significance of his mental disorder is that it was a contributory factor. The relevance of other factors, such as any towards more, is not discounted. There had been a suggestion that the delusional disorder was triggered by the poisoning in 2005. This is not our opinion, and the onset of delusional disorder cannot be accurately described. However, it was likely present at the time of the index offence. Delusional disorder is clearly defined, and then the diagnosis does not fall away if the poisoning of Mr. Woods didn't in reality occur. The trouble is, it's not quite clear what they mean by the poisoning, because there's no doubt he ingested poison. Not only does it remain likely that his beliefs regarding the nature of the poisoning are fixed false beliefs based on an inaccurate interpretation of an external reality, but there are other aspects of his beliefs about the victim and others prior to the index offence which supports the diagnosis of delusional disorder. With respect to the response by my learned friend, Mr. Pennington-Benton, there appears to be misunderstanding of the medical diagnosis. And then, notwithstanding that, there is, of course, room for a court when faced to reject it. In Mr. Woods' situation, our opinion is that delusional disorder had a significant impact on him, so that violence was more likely. And we say that would be sufficient, a significant and appreciable contribution to the causation of the killing. The respondent's suggestion that Dr. Latham's report failed to take account of the differing accounts given by the appellant is contradicted by the report itself. Can I just give you the references? He refers to the accounts of other witnesses suggesting a history of violence at paragraph 34 on page 407. He refers to the police report made by the appellant regarding the poisoning at paragraph 38. He also refers to the interview notes taken by the appellant's lawyer at paragraph 44. That's page 409. And that includes the statement, the children are lying on me. And we have that at page 100, the statement, the children are lying on me, you will have seen in the notes. So he does look at everything. And now in his further report, again, my lords, it's a matter for you whether to admit the further report. We make one simple point. If you look at the objections, they were very, very skimpy. And they were saying, well, it may well be you want to admit this evidence, but his views are tentative and untested. Then we receive, after we've settled our case, a 24-page, I'm not criticising, but full-on onslaught on the credibility of the witnesses and the credibility of the account. It isn't unreasonable to say we should be permitted some detailed reply to that. And if Dr. Latham is able to deal with some of the issues, such as fabrication, such as inconsistent accounts, such as they say you don't identify the exact point at which the diminished responsibility kicked in, and his reply is it was there influencing him probably for weeks before the killing. They say you don't say at which point was it when he picked up the cutlass. That's a gross oversimplification of how they're saying diminished responsibility operates. For a start, the intellectual disability is always there, operating in its effect on his ability to control himself. But secondly, if he does suffer from delusional disorder, you can't say, did it kick in when he picked up the cutlass? No, it was there all along, affecting his decision-making when he went along there with whatever intent he went along. So, my lord, we say that to that extent, we would respectfully ask that you admit Dr. Latham's report. But
if it was sent back to the Court of Appeal and they didn't end up finding diminished responsibility, would it still be relevant in that you tell us he'd now be entitled to have his sentence commuted, and the Court of Appeal would then need to substitute a new sentence, and it would be relevant in deciding what sentence was appropriate to take account of expert evidence about his psychiatric state, even if it didn't amount to a successful defence?
Well, yes,
is that right? As in Pittman, is it similar to that?
Yes, but can I just say this? It's quite difficult. The sentence is mandatory. That's to say the death penalty. By way of a constitutional motion, you can get it set aside because he's been on death row for 5 years. There is a debate as a result of the Privy Council's decision in Pittman itself, I think it was, number 2, as to whether the court can then substitute an appropriate sentence. In fact, they're doing...
I thought they did that in Pittman.
They did, but then they were told they shouldn't have done it.
Oh, right.
Privy Council, but they're carrying on doing it anyway. and quite sensibly in our respectful submission, because if you've got the case before. I mean, otherwise, every time you want to do something, you have to start, these are indigent people on death row, you have to start a constitutional motion to set it aside and then say that as part of the commutation you should take into account all these matters. But my lord, I won't. But my lord, we say it would be relevant.
Can you remind me? I think I was in these cases. Wasn't there something like a 7-judge case which then got overruled about 6 months later by another?
Your lordship's absolutely right. So what happened was, just very briefly, and I'll be corrected if I get it wrong. Originally, the Privy Council said you can substitute a sentence of life or less than life in the exercise of judicial discretion.
Yes, that was Lord Toulson's judgment.
Exactly. That was challenged.
And then he recanted in the later case.
That's what they came back and said, you can't do that.
Yes.
And so the Privy Council said, you can't do it. But in fact, they're doing it. Because it's
but the law we've laid down is...
Yeah, I'm afraid that's
right.
My lord, that is the...
Yeah.
I accept. But you could do it, so strictly speaking, you can only do it by way of constitution.
It hinged on the jurisdiction being exercised, and it was a constitutional jurisdiction rather than a conventional criminal appeal jurisdiction.
Your lordship's absolutely correct. The question is, can you, in the exercise of criminal appellate jurisdiction...
But surely you could have a motion listed for hearing at the same time, couldn't you?
Well, you could.
Deal with them at the same
time. My lord, you could. My lord, then that may be the solution. But it clearly would be relevant. But my lord, the other point is, and my learned friend Mr. Hall's going to deal with this, it would be relevant to the subjective issue of provocation too. The issue was, did he lose his self-control? You have to look at any disability, which would certainly include the low intellectual functioning and such delusional disorder as was found. So, my lord, that's Dr. I've dealt with Dr. Lath and Dr. Attard. We deal with that in the case at paragraphs 21 to 23 of the case. But can I just give you the key bits? At paragraph 89, which is page 450, he says that he did suffer from an intellectual disability in the light of Miss Leewar-Cooper's assessment, and he makes the point about 1 in 1,000. 999 would have thinking and reasoning abilities that exceed his, and we draw the analogy with the Pittman case at paragraph 27, page 950. Delusional disorder, he deals with, he carefully reviews all the background evidence at paragraphs 92 to 102, page 452. And there we go. It's so paragraph 100, page 452. Whilst he deals with that, he deals with at paragraph 98. It's a fixed false belief based on an inaccurate interpretation of external reality, not congruent one's culture, and then he deals with maintaining them. There is evidence that ingested a toxic substance which led to his hospitalisation, so that's clear. Whilst it is not impossible that the victim of the index offence poisoned Mr. Woods, it's outside of a psychiatric expert to make such conjecture. I think what he means is, it's not for me to say, I think that she poisoned him. But
I mean, that isn't even the question. I mean, the question is, was there a basis on which he might reasonably believe that she had?
Yes. Well,
you know, because this is all about beliefs. Are beliefs delusions?
Yes.
Or, I mean, the converse isn't are they true, but perhaps are they reasonable?
No. Well, my lord, I do accept that. But if in fact she didn't do it, and all he knows at some stage, all we know for sure is he ingested something which was poisonous, then we would submit that his obsession that it must be her, and it's part of, and she's trying to kill me generally, is delusional for all the other reasons too. As I understand it, there's no evidence to suggest the victim of the index offence did administer any poison. Did I understand from the medical records? he was taken to accident and emergency in an unresponsive state after being found by wife at home. So, I mean, that's one point. I think she also said, well, I took it too. Despite Mr. Woods having subsequently reported the matter to the local police, there's no evidence to suggest ever suspected. I've therefore considered his belief regarding the victim wishing to kill him and poisoning him in February to be a fixed false belief based on an inaccurate interpretation of an external reality, despite evidence to the contrary, which he has maintained for almost 20 years. So that's how he comes to his conclusion in all the circumstances. Now, my lord, we say that that is a reasonable basis for him to reach his conclusion that it is delusional. And then he makes the point that psychotic disorder, paragraph 102, the presence of mental disability is also relevant. And the last sentence of 102, psychotic disorders have been found to be more common in adults with intellectual disability than those without. Such is likely that Mr. Woods was more vulnerable than the background population to develop a delusional disorder. And then he deals with the question of, if it was there, did it have an effect on him? And he deals with that from paragraphs 108 at 454 to 455. He says he was suffering from an abnormality of mind at 110, page 454. He explains that it arose from his intellectual disability and his likely delusional disorder. And then he says that they had a significant impact on his mental state and functional ability. My Lord Lloyd Jones asked the question, can you, as it were, disentangle the two? They don't actually conduct that exercise, but they do indicate the effects of each of them could be to affect control and to affect thinking. So to that extent, it is freestanding, the intellectual disability. And then faces significant challenges. His communication ability encompassing speech vocabulary, this is at the top of page 455, all registered extremely low when it comes to making choices, exhibiting self-control, etc. And then, so that would affect his responsibility. And then at 113, the delusional disorder had an impact on his functioning at the time of the index offence. Can lead individuals to make decisions based on the rather than rational thinking. And in consequence, this is at 114, it is likely the abnormality of mental functioning impaired his ability to form rational judgment, impaired his behaviour and consideration of consequences at the time. So that's the key. I think you have seen Liwa Cooper. I've taken you to the main points, but if I could just briefly summarise her, it's at page 419 that she deals with the full-scale IQ of 53, lowest 0.1% percentile. She also identified an extremely low conceptual functioning score of 62. That's at page 423. And then finally, if we go to her clinical summary at 425 to 6, 425 to 6, she sets out the various effects. You see, the FSIQ is at the second paragraph down, affecting his ability to think rationally and express himself, leading to disordered logic. Next paragraph is about his adaptive functioning, which would affect his extremely low score on that, which would affect his powers to exhibit self-control. So that's near the bottom of the third paragraph. His overall adaptive functioning may be limited to his extremely low intellectual ability. His ability to seemingly function in everyday tasks may be attributed to repeated practice, so as it were, learning to cope. And then at the bottom of the page, Mr. Woods' executive functioning falls significantly below the expected level for his age. This underdevelopment suggests that he may struggle with self-control, exhibit great impulse, and experience heightened disorganization. Furthermore, he may encounter challenges in shifting and maintaining his attention between tasks. So, my lords, that's there all along, and it's actually as Leewar Cooper says, the IQ test is, results are lifelong. And so we say that that is an operative factor contributing to his inability to control himself and to his violent behaviour at the time of the killing. We've got the joint statement at page 461, and we draw attention in particular to paragraph 5 of the joint statement at page 464. I think I took you to that, my lords, because that was important. That they say the diagnosis does not fall away, remains likely an accurate interpretation, explains that the delusional disorder is known to be associated with violence. This is significant, we say, given the body of evidence of the appellant making threats to kill and resorting to violence.
And what page of the joint expert, the electronic bundle was that? My
lord, the bit about is page 464, my lord.
Right. 464
in paragraph 5. Does my lord have that? Yes.
Yes, we've seen it before.
Thank you, ma'am. Yes. So, my lords, then, can I just briefly address some of the points made by my learned friends? Firstly, there's a dispute as to the delusional disorder. They take issue without any independent expert evidence with the unanimous expert evidence that he does suffer at the time and now suffers from a delusional disorder. They assert that the belief that he was being poisoned was factually based and therefore provides no evidence of a delusional disorder. Well, there are two replies we make, which the court may or may not find helpful. On the first, we say that there is factual evidence to suggest that Miss Miller was not in fact seeking to poison him. She finds him, she refers him to the hospital, so that therefore he doesn't pursue his complaint to the police, and they take no action. But despite those pointers to the contrary, he maintains his belief. So that is indicative of delusion. Moreover, then there's the clinical judgment of both Dr. Latham and that his beliefs about his wife are delusional because they are held with a fixity, persistence, and insusceptibility to reasoning, which is characteristic of a delusional disorder. That's Dr. Latham, at paragraph 50, page 411, and at paragraphs 53 to 4, at pages 412 to 413, and it's Dr. Attard at paragraph 100, page 452, and the joint statement at paragraph 5, pages 463 to 4. But my lords, it doesn't stop there, because the psychiatrists also identify further aspects of a delusional disorder. Those include the appellant's unreasonable belief in his wife's serial infidelity based on distorted perceptions. That's to say, the smell that he identifies, and that's Dr. Latham at para 54, page 413, Dr. Attard at para 94, page 451, and the notion that he was being followed by her new partner in the run-up to the killing. That's Dr. Attard at page 451, para 95.
Sorry, Attard?
Attard, page 451, paragraph 95.
Thank you.
And there is also, just to give you the other reference, which is he clearly was telling his lawyer in the interview with his lawyer about he looked at me in a hostile way and cussed me out. And there's no evidence that actually did occur. Indeed, I think Lawrence says he'd never talked to him. So there are considerable pointers to the development of paranoid ideas. And then as to the explanation, again, they say, the respondents say, this is their next point, you haven't explained in any way how the disorder's diminished responsibility at the time of the killing. We say that is, in fact, that's in their page 569, in their case at 52.4 and 52(5). But we say it's fully answered by the experts. They explain that the combination of significant intellectual disability and a delusional disorder would have affected the appellant's power to reason, his perception of events, and his ability to control his actions in the period before and at the time of the actual killing. And then on this, Dr. Latham explains his position at electronic bundle, page 413, paragraph 55, in terms of the appellant's loss of powers to reason and to exercise self-control, resulting in a diminution of responsibility. And Dr. Attard likewise explains the appellant's intellectual disability would diminish his power to reason and exercise self-control. That's at paragraph 112, page 455. And he further explains that delusional belief would distort his perception of reality and impact his ability to manage and control his behavior. That's at paragraph 113, page 455. And it's also the joint conclusion, which I took you to, at paragraph 5 of the joint conclusion, page 464. And those are the precise tests. That's to say, is his ability to control himself affected by his underlying disorder, which is the test for diminished responsibility ever since the case of Byrne, which you have at tab 30, page 1087.
Page
1087, my lord. Basically, they said abnormality of mind, its effect on all the aspects of the mind, including the power to the exercise of self-control, the exercise of willpower. So if you can say, I have this underlying disorder, it affects my power to control myself in significant and appreciable ways. And there's evidence that you do lose your self-control, and maybe have lost it for some time. But even if you just lose it on the moment, as with a problem, then that is a contributory factor, and that's all you need. It doesn't have to be the whole explanation. It just has to be something that in the law's leniency towards those with a disability recognises that it would have been more difficult for him to control himself. Does it then have a significant and appreciable effect on his powers of self-control? And we respectfully submit that the simplistic thing, was he suffering from diminished responsibility when he picked up the cutlass? Was he when he went into the room? Was he when he... The answer is it was affecting him all the time. And it was certainly affecting him in a moment of high emotion when he was acting violently. And, my lords, I've given you the test for substantial impairment. Did my lords have... It's the Golds case at paragraph 40.
Paragraph?
Paragraph 40, page 37 of the supplementary. I mean, can I just... If I just have a quick moment on that. There was a case called Lloyd, which is in the bundle, which said what you should direct the jury is substantial means more than minimal, less than total, or more than trivial, less than total. In the case of Gold, the Supreme Court said that needed some refinement. You really should just say substantial and leave it to the jury to decide whether there was substantial impairment. But that if you wanted to elaborate, they gave some possible elaborations which would be appropriate, but the best one, perhaps, is the expression significant and appreciable, and that's at paragraph 40. So it was a slight hardening, because, well, my lords, I know the court will be fully aware. The word substantial can mean all sorts of different things. I mean, if you're trying to lock someone up, you say substantial risk, it means more than minimal. If you're trying to let someone off, it apparently means something more than minimal. It means significant and appreciable. But one can understand that because it's about what the policy of the law is. But that's what Gold says anyway, and we would say we certainly have adduced evidence which would satisfy that test of a significant and appreciable effect on responsibility. And then finally, there's the respondent's point that the appellant has changed his account. That's in their case at paragraphs 47 to 48, pages 566 to 7, and that the experts failed to address this. Well, it is addressed in Dr. Latham's reply, but in fact, they did address the fact, they did set out the accounts. But the accounts that they set out, so what they do is they set out their paragraph 47. First of all, he denied it altogether. Then he doesn't deny it at trial. He just says, I lost it and I can't remember. And he says the same to Dr. Latham. And then he seems to have some recall because he's saying to Dr. Attard, I only gave 3 chops. This, we say, is to some extent is the flounderings around. But the key bit is his trial evidence was not denying that he did it. That's his sworn evidence at trial. But just saying I lost it and effectively conceding that he must have done it. And that's consistent with what he told Dr. Latham in admitting that the appellant was responsible for the killing and in saying that on finding Miss Miller in bed with Mr. Stewart, he, quote, tripped out. And my lord, you've got the various ways in which he explained the expression tripped out as I didn't know myself what I was doing. And that's at page 223. I don't know myself. I mean, I don't know which part I was and what's going on in my life. And it does appear that he was in a pretty disorganized and confused state at that time. It appeared from one of his sons that he'd lost his job, actually, fishing. But things were going, as it were, downhill. As to the appellant's initial denial of the offence in his account to his attorney, this is best characterised, we would say, as a childish evasion that was not repeated on oath at trial. Neither the account itself nor the abandonment of it suggests any astute tactical thinking. And they say this shows astute tactical thinking. I mean, really, astute tactical thinking. A 6-year-old child says, I didn't do it, he did it. And then on oath says, well, I can't remember it, but I must have done it, as it were. And there's clear precedent of cases where appellants have altogether denied responsibility on oath at trial and then advanced diminished responsibility on appeal. Erskine is one, page 1198, you'll see the headnote of Erskine, where it's tab 1198 of the bundle. I can just get it from he, in his case, killed a series of elderly people. The evidence was never ventilated because the defendant consistently denied any involvement or responsibility for the killings. That's in the headnote at 1198 at E. And then in the end, they say, well, it's obvious that he was diminished, so the fact that it was his own silly fault is neither here nor there, and that's at paragraph 95, page 1222. Unequivocal contempt that his mental was substantially impaired. And then there was the real problem about what do you do if you think your client is mentally disordered, but he's denying it, and the answer is you can't go behind your client unless he's unfit to plead. Winston Solomon, again, which you have, he was denying it altogether initially, and you've got that at, it's referred to in Pitman, but you've got it at supplementary bundle tab 2 in the head note at pages 5 to 6. He was totally denying it, and then it became clear that he was mentally disordered. And Pitman, number 1, tab 20, page paragraph 31, he denied it.
Well, being mentally disordered is not inconsistent with being untruthful.
Exactly. Being of childlike. I mean, you know, we've got rid of intellectual ages, as it were. But the fact is, if you've got an IQ of 53, you're right at the bottom. right at the, I mean, 70, which as you can see in the Pittman case, 70 was regarded as a significant cut-off point for significant.
Well, Pittman, I think, was similar.
Yes, he was.
Because he was 52 or something, but
Yeah, 52.
73 is after you take account of his adaptive ability, isn't it?
Yeah.
Which is rather similar here,
Yes,
because he's got rather more functioning capacity than his IQ suggests.
Yes, yes.
He can do. The evidence seems to be that he can do things in life because,
My lord, yes.
even though he's incredibly low IQ, but he can still
Yeah.
go fishing and
Yeah.
things he's learned to do. He can.
Yes, yes. He said, my mother taught me, how to cope, as it were. Well, my lord, that's absolutely right. Well, and then of course, the courts understandably hoist warning signals where the person denies it at trial, but it is not fatal. See Erskine, Solomon, Pittman, and numerous other cases, and it's analysed by the Chief Justice de la Bastide. He cites the case of Heather Arnold, where the court says even if it's their own silly fault or their own misguided fault that they deny it, we then have to look at whether there is evidence of diminished. And then as to the inconsistencies, we say that actually his account at trial and his account to Latham, that's to say, I did it, but I can't remember the details, is consistent. It's quite true that when he's speaking to Dr. Attard, and it's recognised in the joint report, he says, "Oh, I only did 3 chops." But again, that's we would say puerile evasion rather than astute tactical thinking, as it suggested. And then we would say that the narrative is that he was actuated by anger from the sense that he had been poisoned, and that he was, or may well have been, influenced by finding her with his successor, the new partner, as it were, in bed, in a state of undress on the day of the killing. I
think his evidence about the cutlass at trial was that he didn't. It was there or in the house, and he didn't bring it with him.
Oh, my lord,
which he now seems to accept that he did.
Yes, my lord, I agree. Yeah, that is correct. Yes, that is correct. I think, and all the witnesses said he came in with the cutlass.
But he even told Dr. Attard where he kept it.
Yes, that's quite. I don't want to trespass on my learned friend. I know my learned friend is going to deal with cutlass, but that is correct. But he may deal with it. So, my lords, and you have our plea tonight. It's no more than that we weren't. If you look at what they said in their notice of objection, these points made, the respondent can see there is some evidence giving rise to the question of whether Timmins ought to have been part of the evidence going to the failure to raise the point below, considers it appropriate simply to leave the question of permission to appeal on this point to the panel. Well, that may have been a correctly modest and moderate position at leave. Now that leave's been granted, they've come up with a full-on onslaught, and we've sought to meet it. But our psychiatrists didn't have notice of that was going to be the full-on onslaught when they dealt with this matter. And so can I just summarise the points we make? We say, firstly, the respondent is wrong to suggest that the evidence of delusional disorder is weak and untested. On balance, it is more likely than that there was no poisoning, and there's certainly an issue which should not be resolved adversely without a full review by the Trinidad Court of Appeal. I suppose things like the medical reports could be gone into then, but in any event, the overall clinical judgment is justified that the appellant has a delusional disorder which is exhibited in his fixed and unalterable conviction that he was poisoned by Ms. Miller. In addition, there are further aspects of his delusional disorder, including his belief in her serial infidelity and his belief he was being followed. Secondly, the respondent is wrong to suggest that there's no explanation of how the appellant's disorder affected his responsibility. We say it was dealt with, and it is dealt with, that delusions, if present, are constant, and that's why he complained to the police, That's why he was accusing his wife, C. Alan Porter. It's what he told his lawyer on his first interview and his second interview with his trial lawyer, and it's what he told both psychiatrists. There's no doubt that he's obsessed and believes that. They're wrong to suggest that diminished responsibility would have been a hopeless defence, given that there is significant evidence of substantial, in the sense of significant and appreciable, effect on responsibility. And then fourthly, their reliance on the initial denial of responsibility by the appellant in his first statement to his lawyer is no reason not to grant leave, given the approach taken by the appellate courts in cases such as Erskine, Solomon and Cardinal Williams, even where the denial persisted at trial. In fact, there is some consistency in the appellant's subsequent accounts, effectively accepting his responsibility for the killing and describing himself as tripping out or losing control and mental clarity. And fifthly, the defence of diminished responsibility is not inconsistent with an account which contains an element of there being a trigger or an additional trigger when the appellant came upon Miss Miller and Mr. Stewart in bed together. The point is that the underlying disorder was still operative and was still driving his actions at the time, even if there was an additional trigger. But we would say diminished responsibility is equally made out, even if the appellant had formed an intention to attack or kill before the fatal incident itself. His action would have been driven or heavily influenced both by his mental disability and his delusional disorder. And my Lord, I think those are really the only points that I have to make. If there are on the diminished responsibility, I slightly rush through it, my Lord, if there are any things that, there is a text with all the references written in if the board wanted to see it. I'm only seeking to tease my Lord. But it does exist if it would be of assistance.
We know who counsel in the case is going to be, Mr. Fitzgerald, when we get the application to admit an extra extra appellant's case, supplemental case, beforehand.
I'm sorry, my Lord. I realise that of course, one ought to anticipate all the objections that are made, and one ought to put everything in at the start, and I apologise for that I didn't. But
well, we like to leave you something to do when you're on your feet.
Yeah.
Well, that's true, my Lord. So that's the yes. So, my Lord, can I cede the baton to my learned friend?
Yes, thank you very much, Mr. Fitzgerald. Mr. Hall.
My Lords, on provocation, there are essentially three broad issues that I intend to deal with. The first relates to the subjective limb of the issue of provocation and whether the judge's direction is materially deficient in the light of the fresh evidence. The second relates to the objective limb of the provocation defence and whether the judge was wrong to direct the jury as to whether the reasonable man would need to do exactly as the accused did, i.e. chop the deceased 22 times. And the third is whether or not this is in fact a case of provocation at all. The respondent says that there is no evidence which could be left to the jury for them to conclude that the defence of provocation arises. And if I may, I'll deal with that issue first. And in my respectful submission, this is a case where the board shouldn't apply the proviso. I accept that there is strong evidence in favour of a premeditated killing. My Lord Legate has already pointed to the issue of the cutlass. There are other factors in the evidence which point that way too. So the example that he'd had a set to, or at least an argument with Mr. Stewart on the day. The evidence from one of the children, Ricky Guy, that he saw the appellant later that day and said that he hadn't finished and that he was going to come back and finish the job. There are, of course, other points, and I'm sure that my learned friend will take you to them. But in my respectful submission, there are, at least for 5 reasons, a basis why this is not a proper case for the proviso to be applied. The first is that there is the evidence of Mr. Woods himself, given in court, that he tripped and that he lost it. The second is that there is the repeated description of the appellant acting like a madman, and that came from Mr. Lawrence Stewart, and my learned friend took you to it. But just for my Lord's note, it's pages 181 to 184 of the bundle. And both during his evidence in chief and during cross-examination, he said 5 times that Mr. Woods was acting like a madman. Again, indicative of a man, in my respectful submission, who has lost control of himself. There's then the evidence of Ryan Woods, who's one of the children. He's the son both of the deceased and of Mr. Woods. And he described the accused as being in a rage. He says, yes, the accused was in a rage that night, and he then went on to say he was moving in a rage. And for my Lord's note, that's at page 210 of the bundle. Again, that suggests more than anger. That suggests a man who has lost control of his emotions. The third point, my Lords, is the sheer ferocity of the attack. It's a point that we will come back to when we're dealing with the issue of do as he did, and we consider the judgment of the Hong Kong Final Court of Appeal in Liang Yaoqiang. But as they noted there, as the Hong Kong Court of Final Appeal noted there, at paragraph 107, which is page 154 of the bundle, a ferocious attack can be indicative of an individual who has lost self-control. The court there said, I'll just quote it briefly, a disproportionately vicious retaliation may be evidence that self-control was in fact lost, although the possibility remains that retaliation could have been carried out as a cool-headed and deliberately sadistic killing, or as an attempt to camouflage the killing as one committed under a loss of self-control. And it is, in my respectful submission, instructive in this case, on the evidence of this case, particularly of Sergeant Williams, who said when he gave evidence that he had been a police officer for 4 months shy of 30 years. When he gave evidence, he said, I have never seen one victim chop with 22 marks. This is the most chop wounds I have ever seen on any victim. That's page 162. So that's an experienced officer giving evidence that he'd never seen such a ferocious attack with a cutlass.
What page of the electronic bundle?
That was page 162 of the bundle.
Thank you.
The fourth point relates to the evidence as to what happened to his youngest son, Darian. He severed the foot off of his 6-year-old son clean off. That is not, in my respectful submission, the act of an individual who is in control. There's certainly no evidence that there was any particular animus between the father and his children. In fact, Mr. Fitzgerald has already taken my lords to the evidence of Ryan Woods, who was 12 at the time of the offending. But when he gave evidence that, and I quote, yes, we would spend the week at Parrot Hall, and then we would go down to Leeward Croft for we self. When we do go down Leeward Croft on a Friday, we go back up by my father the next Friday. So that's at page 207 of the bundle. And then at page 208, he said that despite of the allegation that Mr. Woods had beaten him, during that period of time where there was that separation, clearly, of homes, even if it's not agreed as to whether the relationship had ended, he said, this is Ryan, my father still used to take care of me. So it wasn't all one way that there'd been a complete breakdown of relationship between Mr. Woods and his children. His children seemed to suggest that there was a reasonable relationship to them. And there's also the evidence of the aunt, Marjorie Bacchus. This is at page 118 of the bundle. She said that in March 2005, and she was very clear in her evidence, when it was Darian's birthday, she went to Parrot Hall. And she said, "I saw Uriah Woods in March. Her last son's birthday was in that month, and she invited me up at Parrot Hall. I slept there when they were living at Parrot Hall." So that would appear to be post-dating the evidence from Mr. Porter that she had moved out. But despite the fact that there appeared to be a reasonable relationship between Mr. Woods and his children, you have again the sheer ferocity of the attack. You have, as Darian Woods said at page 212 of the bundle, "My father came outside, dragged me by my right hand and chopped me left foot and then chopped me right foot." And you have the evidence of Ryan Woods at page 205 of the bundle. "He hold Darian to chop off his foot. He hold him by his hand and chop off his foot." In my respectful submission, these acts are indicative of somebody who has just lost control. Fifthly, my lords, we then have the fresh evidence concluding, on the one hand, that Mr. Woods has an IQ of 53, and the clinical term of mild to moderate, which is, I think, picked up by the respondent, just doesn't do that term justice. It doesn't translate into everyday vernacular. A mild or moderate disorder of this nature, an IQ of 53, it means a profound mental impairment. And the joint expert statement shows that his intellectual impairment was severely impaired, his cognitive functioning affecting his understanding, communication, and reasoning, and it also shows an impaired ability to exercise self-control. And it may be that we come back to it, but on that point, we summarise the evidence in the appellant's case at paragraph 17 from the clinical psychologist dealing with the impact that the intellectual impairment has on Mr. Woods. Of course, you also have the evidence relating to the delusional disorder, which Mr. Fitzgerald has taken you to, but the evidence there is that that would also increase the propensity to be violent as well. So this is far from a case where it would be appropriate to apply the proviso, in my opinion. The test, as my lords will be aware, is whether the jury would inevitably convict. And Solomon is an illustration, Mr. Fitzgerald has taken you to it, that even in circumstances where the person's defence was that it wasn't me who did it, it was some third party, where there is some evidence of provocation and there is fresh evidence going to an individual's psychiatric condition, the board remitted the case to the Court of Appeal for it to decide what to do. And the same is true in the case of Lewis, which is in the bundle at page 828 onwards. That was a particularly violent death that the victim experienced. They were, just briefly, my lords, the defendant and the victim were in a sexual relationship. The victim was found with severe injuries, including being hogtied, I think being stabbed, and a gag was stuffed into her mouth, which was made up of a tie wrapped up in tights. Now, Dee said that the defendant had said that he tried to break off that relationship and was terrified that the victim might reveal it, that there had been a struggle between them. And the trial judge himself refused to leave provocation, as he said there was simply no evidence of provocation in that case. The Privy Council said that while there was some evidence from which you could infer that the individual had lost control, the judge, on the evidence as it stood then, was entitled not to leave it to the jury, but that on the basis of fresh psychiatric evidence, which was to the effect that the individual had suffered with vulnerable self-esteem issues, that was potentially relevant to the issue of provocation and again it was remitted to the Court of Appeal. So, however sceptical, in my respectful submission, one may be of the defence in this case, and however strong the misgivings, there's clearly a basis on which to conclude that an individual would have been provoked in the circumstances that Mr. Woods says he was, both from his account and from the surrounding factual evidence. So that's why I submit this would not be a case for the operation of the proviso.
What is said to be the provocation? Is it the fact that his wife or former partner is lying on the bed with another man, or is it anything other, in addition to that?
It's, as I understand it, it's just the former. And of course, that has always been accepted as a classic example of provocation. Before the introduction of the Homicide Act, the 1957 Homicide Act, provocation was governed by common law, and at common law, there had to be some act of violence. There are only two exceptions to that. One was, I think, a father finding his son being sodomized, and the other one was a husband finding his wife being unfaithful. So it's always been accepted that this is that this sort of situation that the accused was met with would be one which is
I mean,
issue.
It's not quite like finding your wife's unfaithful. He knows she left him some time ago and is now living with somebody else in this house. I mean, it's not as though he turns up there and is amazed to find them both there.
My lord,
He's already had an altercation in the street earlier the day with the man he knows is living with his former partner.
Well, just in relation to Mr. Stuart Lawrence living with his former partner, the evidence is that the first time that he'd ever stayed at Leawood Cottage was on the 14th of July, that he'd never stayed there before. I might be able to find a page reference to that. Page 187, the bundle. So it starts, it's just above halfway down. It says,
This is Lawrence Stewart's evidence.
this is Lawrence Stewart's evidence. It is not to my knowing Sandra had her personal items along the corridor. It is not to my knowing whether there was a cupboard on the corridor. I am not accustomed to going to the department at night. I'm not accustomed going to it in the daytime. Yes, on the 14th of July 2005, it was the first time I went there. So they weren't in some form of long-time relationship. And Mr. Lawrence's evidence equally is that he didn't actually know that the accused and Mr. Woods and the deceased used to be together. My lords, go back to page 182. It's just 3 lines up. I did not know the accused and Sandra had finished. I did not know the accused and Sandra used to live together. No, I did not know the accused and Sandra had 3 children. I don't know the accused and Sandra used to live at Parrot Hall for 15 to 16 years. I did not know that Sandra had 4 children before she, the accused.
How does that sit with it now being accepted that he went armed with the machete?
Well, that's not the evidence that he gave at trial. It's certainly the statement that he's now given to Dr. Attard, and it's an inconsistency which is going to need to be ironed out. But whether the board can iron it out at this stage, in my respectful submission, it would need to be something that would to be ironed out on remission. Certainly, the psychiatrists say
Doesn't it
that
go
an
to whether or
individual-
not a jury would otherwise have accepted that there was provocation, that the cause of his behavior was provocation, if it was accepted before them that he went pre-armed with the machete?
My lords, yes, it is a real difficulty in relation to the provocation offence. I would completely accept that. But for the reasons I've given, it's not one which is completely devoid of merit. And there are cases where individuals are in the process of committing other offences. So, for instance, this is what happened in the case of Daniel. I think that the defendant was in the process of committing an armed robbery, during the course of which he said that the victim, I think, assaulted him, which then provoked him, and he shot him. And I think that the Court of Appeal had said that in those circumstances, you induced the loss of control and you can't rely on it. But the board in that case said, no, that's not right. You can, even if you are the cause of the provocation, rely on provocation, even if you've induced it. So if he did turn up with a cutlass, we don't know what his intention was. We don't have any evidence in relation to that from Dr. Attard. But it's something that would obviously need to be dealt with, in my respectful submission, before the Court of Appeal.
I suppose you'll be asking the board to factor into this discussion the evidence of diminished responsibility as well.
If I may then just move to the section itself, which has been set out in the appellant's case, page 530 of the bundle. I think that's the core bundle at page 40, and it's paragraph 38. It reads...
Sorry, Mr. Hall, we're going to the section at page...
So it's 530 of the normal bundle, and it's page 40 of the core bundle. It's paragraph 38 of the appellant's case, which is where section 4B of the Offences Against the Person Act is.
Oh, I'm sorry. What page?
It's page 530 of the electronic bundle.
Thank you.
So your lordships are in the appellant's case there, and we're dealing, and we've set out there the section itself. It says, where on a charge of murder there is evidence on which the jury can find that the person charged was provoked, whether by things done or by things said or both together, to lose his self-control. Now, pausing there, that's what the case law refers to as the subjective inquiry. Lord Nichols in Holly refers to that as the subjective inquiry. It's the factual question: was the person provoked into losing their self-control? And the next part is the objective inquiry. The question whether the provocation was enough to make a reasonable man do as he did shall be left to be determined by the jury. And in determining that question, the jury shall take into account everything both done and said, according to the effect which, in their opinion, it would have on a reasonable man. Now, the case law has demonstrated that that contains two elements. The first element is actually contained in the second clause, and it's referred to as the gravity of the prosecution. And in determining that question...
The provocation.
Provocation. And in determining that question, the jury shall take into account everything both said and done, i.e. the provocation, according to the effect, i.e. the gravity, which in their opinion it would have on a reasonable man. And much of the most recent case law has been about that first element, including what characteristics of the accused an individual can take into, the jury can take into consideration when assessing the effect it would have on the reasonable man. The second element of the objective inquiry is whether the provocation was enough to make the reasonable person do as he did. And then my lords will, I think, see at paragraph 41 of the appellant's case that Lord Hobhouse, in fact, broke it down into four constituent elements there. But in my respectful submission, there are essentially three stages. The first stage, which is the subjective limb, might the accused have been provoked into losing their self-control. The second stage is, might the reasonable man, sharing the relevant characteristics of the accused, have been provoked to lose his self-control. And the third stage is if the reasonable man might have been provoked to lose his self-control, might the reasonable man, quote, have done as he did? I'll deal then with the subjective inquiry and the ground relating to that. We've summarised the relevant principles in the appellant's case at paragraphs 44 to 48. But in relation to this factual issue, it isn't disputed, as I understand it, that all evidence is relevant, including in relation to the appellant's mental health. And you'll see there the quotation from Lord Hobhouse in Smith Morgan. Since this is a factual question, evidence of any mental or other abnormality which makes it more or less likely that the defendant lost his self-control is relevant and admissible, as is any evidence concerning the defendant which helps the understanding or assessment of the evidence of what occurred. Lord Nichols at paragraph 5 in Holly's saying that the evidence which is relevant includes any mental or other abnormality. And he then, Lord Nichols went on at paragraph 18 to say that when considering the subjective ingredient of provocation, did a defendant lose his self-control, the jury must take the defendant as they find him, warts and all, as Lord Millett observed in his dissenting judgment in Smith Morgan. So, my lords, for your note, the appellant's case at paragraphs 49 to 51 cites the relevant parts of the trial judge's direction in relation to this subjective limb, but it obviously doesn't bear much relevance because there is no criticism of the direction in relation to the subjective limb as it then was. The issue is whether the fresh evidence makes the direction deficient. And we have the evidence from those three credible experts which Mr. Fitzgerald has taken you to. And a summary of that evidence is contained in the appellant's case from paragraph 7 to 23. Just very briefly, my lords, paragraph 17 to 20 deals with Miss Lee-Wah Cooper's evidence. And her evidence, in my respectful submission, speaks eloquently to the interrelation that there is between the mental impairment and the impaired capacity to both exhibit self-control and to be violent. And then in addition to that, you have the delusional disorder, the evidence both from Doctors Latham and from Dr. Attard, which shows that the delusional disorder impacts and impairs the ability to exercise self-control. So the way that it is put by the appellant can be found, my lords, at paragraph 52 of the appellant's case. My lords, it's obviously my submission that the evidence ought to be admitted because it's credible and it's capable of belief. And it's also my submission that the evidence potentially materially affects the direction of the conviction such that it might be unsafe. So it's for those reasons that I submit that the matter ought to be remitted to the Court of Appeal, either for it to hear the psychiatric evidence and make its own determinations, including any rebuttal and any cross-examination, or for it to order a retrial, or to decide whether a retrial should be ordered.
Well, that hardly seems realistic possibility at this stage.
Well, my lord, that would obviously be a matter for the Court of Appeal, but I accept that there would be serious issues in ordering a retrial. Mr. Fitzgerald says, and provides assistance, that in Campbell, a retrial was ordered 20 years on, but I accept that a retrial now, in possibly 5 years' time, would pose difficulties. That then leaves me at this stage to move on to the meaning of do as he did, and it may be if I can just give you the structure of my submissions, and then we can return to that after lunch. But the structure of my submission will be, firstly, to take the board to the judge's summing up to identify the issue in the case. Secondly, then to look at the history of the law of provocation, primarily with reference to Lord Diplock's judgment in Camplin. And the point of that is to demonstrate that the introduction of Section 3 of the Homicide Act did away with the triumvirate of cases from the House of Lords, Mancini, Holmes and Beda, all of which had incorporated and introduced and then emphasised the need for a proportional relationship between the resentment and the mode of killing. Thirdly, I will then deal with the decision of the House of Lords in Acott, and the point is simply to underline that Section 3 did abolish those decisions, and that to the extent that proportionality is relevant to the objective criterion, it is relevant to the second limb only. Sorry, it is relevant to the first limb only, namely the gravity of the provocation on the accused as measured by the reasonable man. Fourthly, I will then deal with the decision in Phillips. And the submission there will be that Lord Diplock materially misstated the law by concluding that Mancini remained good law following the introduction of Section 3 of the Homicide Act, and that in effect Lord Diplock reanimated impermissibly the need for some form of proportional response within the second limb of the objective inquiry. Fifthly, I'll then deal with the decision of the board in Rampheret, and the submission will be that that judgment was simply wrong to rely on Camplin for the proposition that proportionality remains relevant to the second limb of the objective ingredient. And then sixthly, I will deal with the decision of the Hong Kong Court of Final Appeal in Liang Yao Kiang, and recommend especially its reasoning as to what it describes as the policy underlying the defence, and what can also be described as an issue of logic, namely that once it's accepted that a person has lost control of himself, it's not right as a matter of fairness or indeed logic or justice to restrict the person's response to or within a straitjacket of reason. It would ultimately be a non sequitur. And then, my Lord, seventhly, I'll just finally make some concluding remarks. So, my Lords, that's the structure of the submission in relation to do as he did. I note the time. I'm happy.
You'd rather start on this at 2 o'clock?
My Lord, I'd be grateful.
May I, just before you rise, President, I wondered, Mr. Hall, whether you'd accept that if the Court of Appeal were to refuse the evidence, the expert evidence, for the purpose of the diminished responsibility defense, that they would hardly likely accept it for the purpose of the first limb of the provocation test. Will you accept that?
I wonder if I could answer my Lord's question
Afterwards,
lunch,
okay.
That'd be grateful.
Thank you.
Very well. We'll adjourn and resume at 2 o'clock.